Today I'm going to provide a summary of Assembly Bill 2992, which was passed to address recent changes that happened in the real estate brokerage business due to the settlement of the National Association Realtors antitrust lawsuit. The new law will go into effect January 1. It affects nearly all real estate sales, excluding leases, rental agreements, and sale of state or federal land and loan brokerage services. Simply put, AB 2992 requires all buyers and brokers to enter into a representation agreement as soon as practicable, but before the buyer submits an offer to buy a property. By the buyer-broker representation agreement, a buyer will authorize its buyer's agent to provide specified services on behalf of the buyer, which by statute must include 1, the broker's compensation, 2, the services to be provided by the broker, 3, when the compensation is due, and 4, the date the broker representation agreement ends. The statute is silent regarding what happens if the buyer refuses to sign an agreement, but presumably the broker can then elect not to represent the prospective buyer. The buyer-broker representation agreements cannot last longer than 3 months or 90 days from the date the agreement was made, unless the buyer is a corporation, limited liability company, or a partnership. The buyer-broker representation agreements cannot automatically renew, again, unless the buyer is a corporation, limited liability company, or partnership. Renewals of buyer-broker representation agreements must also be in writing and dated and signed by all parties to the agreement, and again, cannot exceed 3 months in duration from the date of the renewal, again, unless the buyer is a corporation, limited liability company, or partnership. Additionally, the buyer-broker representation agreements and renewals must include a statutory notice that compensation to the broker is not fixed by law and is negotiable. Any buyer-broker representation agreement, including renewals that does not comply with the new law, is void and unenforceable and can constitute a violation of the broker's licensing law, which may then make the broker subject to discipline.